Is there a danger to you saying no to the defense's settlement offer? You want to learn the answer to the question? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is yes, there is a danger to saying no. What's the danger? The danger is now you have an unknown. So let's say it's now 2 or 3 years during the course of your litigation, nobody's made any settlement offer whatsoever. But now, as your case is approaching trial, and whether it's a car accident case, or a medical malpractice case, or even a wrongful death case, now finally the defense turns around prior to trial and makes you a settlement offer. And you are furious, you are outraged, and you say, absolutely not, I am not taking that offer. Now you're not willing to negotiate, you're not willing to make a counteroffer, you're not willing to see whether they're willing to come up from that initial offer. So what you've done is you've cut off all settlement negotiations. So is there a danger? Is there a risk to doing that? The answer is absolutely. And what's the risk? The risk of you cutting off all negotiations mean that you now are definitely going to trial. And what does that mean? It means that you now are leaving the value of your injuries up to a jury. And now, that could be good, or on the other hand, it could be bad. It could be bad for a number of reasons. Your case may not be as strong as you think it is. And you may get stuck on liability where the jury comes back and says, we don't think that you are more likely right than wrong, that what you are claiming is true, that the other driver was careless. And if that's the case, they're going to leave you out of court without a dime. Or maybe they find that you are partially responsible for your own injuries. In which case, that if they do give you money to compensate you for your injuries, now your amount that you're getting is going to be reduced by the percentage that you are found to be at fault. So now when you rely on a jury to come to a conclusion about whether or not you are entitled to get compensated for the injuries and harms that you've suffered, you are taking a gamble. It's as if you're rolling the dice in Atlantic City and now you're throwing the dice and hoping that it comes up in your favor. That's exactly what occurs, even though you strongly believe and firmly believe that you have evidence and testimony to support the fact that you have a valid case. And then even if you do have a valid case, then the jury has to evaluate the extent of your damages. What are the damages? And now you may think that they're worth a certain amount. The jury may agree with you. They may disagree and give you less. They may agree and give you more. The problem is it's a total unknown. So to go back to the original question, is there a danger of rejecting the defense's settlement offer? The answer is there is always that danger and always that risk. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on during the negotiation process in a lawsuit involving car accidents and medical malpractice and wrongful death here in the state of New York. I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in the state of New York and you do have legal questions, what I encourage you to do is, you know what I'm going to say, right? Come on, pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.